Hello, and welcome to another episode of Good to Know Estate Planning Topics. Today we're going to talk about, so you've decided not to get married. Growing numbers of Americans are deciding not to get married. Younger people are marrying later. Older Americans who have previously been divorced or who are widowed are deciding not to marry again. Even same-sex couples who now legally can marry are deciding that it's just not for them. While these are all valid choices, it's important to know what you're giving up by not getting married. For example, legally married couples are entitled to leave their entire estate tax-free to their surviving spouse. But for everyone else, their estate is subject to estate tax over the exemption amount. Additional benefits provided to married couples include Social Security benefits, immigration status, the right to decline to testify against a spouse, joint bankruptcy filing and protection of spousal obligations, surviving spouse benefits, benefits under a victim's compensation fund, for example, the 9/11 victims funds, hospital visits, and of course, inheritance benefits. In California, there is no common law marriage. So regardless of how long you've been cohabitating with a person, the court will never consider it a legal marriage. So without additional planning, the survivor is not entitled to any legal benefits, notice in a probate proceeding, or continuing support that is afforded to legal spouses. To illustrate this point, let's imagine that there's an older couple. They've each been widowed or divorced. They decide they want to be together, but it's just too complicated to get married and share their finances. The woman sells her house, moves into the man's house. They share expenses. They live as a husband and wife would, but they never actually legally marry. She takes care of him through an illness, through his death. His family may visit occasionally, but after his death, his family could open a probate proceeding and require her to leave the house. She has no legal right to stay there. It could be even more tragic for a younger couple. Let's say neither is close to their family. The couple is in a horrible car accident and she is in intensive care and non-responsive. Not only is he not allowed to see her, her family arrives and starts making decisions about her health care that he knows she wouldn't want. But he has no legal rights and the family shuts him out. To add insult to injury, she dies and her family is entitled to any assets that do not have a beneficiary named. Fortunately, much of this can be addressed by some proper planning in advance. Generally, if you live in California and have over $150,000 in assets, you want to execute a revocable living trust. Within this trust, you can name anyone you want, including a cohabitating partner, as your trustee and beneficiary. It's also really important for unmarried people to execute a power of attorney and an advanced healthcare directive so that you can name the person you choose to make your financial and healthcare decisions for you in the event you are not able. We live in an amazing time where people are defining what it means to be a family. As you take charge of your life this way, know the costs and benefits and do the proper planning around them. My name is Smyser, and I'll see you next time on Good to Know Estate Planning Topics.